I'm sorry for the technical hitches, which actually stopped me in the middle of the sentence. So I was saying that Puma was actually even relocating their production from Vietnam to Cambodia purely because of the effects of the generalized system of preferences, generalized scheme of preferences. So there are three levels: standard GSP for low and lower middle income countries, then GSP plus when the tariffs go to zero for those low and low middle income countries that actually implement conventions on human rights, labor rights, and protection of environment and good governance. And then there is a third group of countries within the European system called everything but arms. It's a special arrangements for least developed countries, and then products coming from these least developed countries are subject to duty-free and quota-free access with the exception of products that are arms and ammunition. So which are the countries that are benefiting from the scheme? Well, countries change, and clearly the European Union has the system of graduation of its country of other countries from the beneficiaries scheme. So if the country has developed in a view of the European legislator, then it is no longer beneficiary. Here you can see the list of countries which are subject to standard GSP, GSP plus, and everything but arms. So you see that now Vietnam is just GSP, no longer in everything but arms rules. So indeed, here you would not now be subject to complete abolition of import duties and quotas when we talk of tariff rate quotas clearly, but it will be subject to just the reduction of tariffs. How does it work? So to begin with, in order to understand why these countries are included and others are not included, because there were times when Russia was a beneficiary to the GSP, the EU GSP regulation gives us the logics. So for the European purposes, developing countries are considered as beneficiaries of GSP, are considered developing actually, if they are classified by the World Bank in their classification as income level below upper middle income. So you can open the World Bank classification and you may see that based on various criteria, the World Bank classifies countries based on their level of development. And these exactly criteria were used by the European system of GSP. The tricky thing is that within the WTO, we don't have any uniform approach towards developing countries. There is no list of developing countries for the WTO purposes. Therefore, countries are free to determine their own lists. However, the World Bank's list is used by many countries, but as you'll see, countries use it differently. So here we talk of everything below upper middle income. Least developed countries. For the least developed countries, it is automatic granting of benefits under the everything but arms. So these are the countries which are at the lowest level of development. Their overall percentage in the global trade participation is less than 1%. And the list of least developed countries, however, is available. It is prepared by the United Nations. And you may see this list on the UNCTAD, United Nations Conference on Trade and Development website. There is this list as of today, and there are 42 countries classified by the UN as least developed countries. So these countries will fall within the ambit of everything but arms. So within the EU, if you produce a product there, then you do not pay customs duties. It makes a lot of sense then to go to those countries, invest, and that is actually the idea how to stimulate investment and production in those countries. But bear in mind that you would need to demonstrate the European customs authorities that indeed you are now working with a product originating in that country. There are special rules of origin which will apply. So not every country that is just brought from those territories will be subject to those preferences, because otherwise businesses would send their products there, repack them, claim those to be produced, say, in Angola or in Cambodia or in Ethiopia, and will seek the reduction or elimination of import duties. No, there will be a special procedure on the checks of origin. There are special rules of origin that will apply, and you would need to demonstrate the customs officials that indeed your product originates from this territory. And this is the reason why there is a separate agreement on rules of origin available within the WTO Annex 1A, because those disputes on origin may very well matter for businesses, because it implies hundreds, thousands, millions of US dollars at stake, because you can either save on import duties or you have to pay import duties at a higher level if you do not demonstrate the origin in a developing or least developed country. So how does the system work within the EU? All products that are subject to GSP, as we said, it's about 2/3 of all products at all from the combined nomenclature, are classified in 4 groups. The so-called very sensitive products. In that case, there is a tariff discount of 15%. Then sensitive products, there is a discount of 30%. Semi-sensitive 35%, I'm sorry, 65%, and for non-sensitive products, for the general GSP scheme, non-sensitive products will be subject to free entry duty-free. How do you find out if your product you are interested in is sensitive or semi-sensitive or very sensitive? You just need to go to the Commission website, European Commission website, and check the EU regulation on GSP. And you will find their list of sensitive, very sensitive products, and so on. So for instance, here is the example of the list of very sensitive products, just a part of it, the very beginning. So you see that these are the products which are considered most sensitive. Therefore, in respect of these products, you will only get, if you bring this from the country GSP beneficiary, you will only get a 15% discount. Then further discounts depending on the category. You scroll down the tables, you find out the products you are interested in. If it is at all subject to GSP scheme regulations, then you identify, you calculate what will be your discount. So here is the example for, say, very sensitive product. Fish meat, it's considered very sensitive. It is there in the list. How do you calculate it? So the MFN rate with the rest to the rest of the world, right? Non-discriminatory rate is 9%. Then you, if you bring your product from the developing country, which is GSP beneficiary, you are eligible for a 15% reduction. So at the border, you will not pay 9%, but 7.6% of the value of the product. It really matters when we consider big consignments, which are relatively expensive. So 1% may seem nothing for at first glance, but if you convert it into dollars, it gets impressive. So that is how the EU GSP works. And well, actually, as I said, here you just need to find out what is the product at stake, whether it is sensitive or not. It's there in the GSP regulation, and then you calculate your applicable rate of GSP duty. The same system of preferences, well, it's not the same. The generalized system of preferences for developing countries has also been developed by the Eurasian Economic Union, and it is there in the decision of the Council. You can find all the details, and again, it works a little differently because here the classification is a little different. There are just 2 big groups of countries within the Eurasian Union. If you are a country classified by the World Bank as high, not classified as high income and upper middle income, everything below that level is subject to GSP preferences. So if you bring a product from the country which is not classified as such by the World Bank, then your product has the right to get a 25% discount on tariffs. Again, similarly for those products which are subject to tariff preferences. For the least developed countries, same approach, duty-free imports based on the same UN list. So when choosing where to locate your production, you may well take into account these factors, because when once you think of exporting your product, say to Russia, EU, or US, establishing a facility in a least developed country could save you a lot of costs on tariffs, import tariffs, in the future international trade of those products which will be produced in those facilities. However, there are clearly also disadvantages. Maybe the governance is not always as good as you are used to, or you may not be happy with the level of corruption in those territories. Or, well, alternatively, if you work hard enough, you may find solutions. But at least these are the incentives to stimulate development in those territories. There is a list of goods that are subject to tariff preferences in the Eurasian Economic Union. You can also find it on internet. It is available, so you just find out whether your product falls within the scope of the regulation or not. If it does fall within the scope of the regulation, quite simply identify if your country would be considered a developing 25% discount, or if the product originates from a least developed country from the UN list, then you have all the rights to seek duty-free imports, provided you demonstrate the origin of the product and the customs authorities of the Eurasian Economic Union members are satisfied with your origin certificates. So how is it all worded in the enabling clause? The enabling clause permits these schemes. How is it phrased? It says, notwithstanding the provisions of Article 1, contracting parties may accord differential and more favorable treatment to developing countries without according such treatment to other contracting parties. So this is exactly how exceptions are worded. They say, disregarding the provisions of Article 1, notwithstanding the provisions of Article 1, WTO members can still give preferential treatment to developing countries with respect to the following, and here it comes, Article 2A, preferential tariff treatment accorded by developed contracting parties to products originating in developing countries in accordance with the generalized system of preferences. So this is the legal ground for these preferences we are talking about. What is this decision on generalized system of preferences, and what is it generally? What are the typical features which we need to demonstrate in order to implement such schemes? If we would look at this old GATT decision, which is also made part of the context of the interpretation of the enabling clause, clearly we need to emphasize three elements which shall be necessarily demonstrated. So such preference schemes shall be generalized, non-reciprocal, non-discriminatory, and give benefits to the developing countries. That is important. These very words are also used in the footnote to Article 2A of the enabling clause: generalized, non-reciprocal, and non-discriminatory. So this is what we need to understand now. How does it work? What is meant by generalized? What is meant by non-reciprocal? And what is made by non-discriminatory? And there was a big dispute which actually happened in late 1990s between India and EC with respect to the European tariff preferences under the so-called drug arrangements. India was claiming that for whatever reason it was not subject to tariff preferences, whereas its level of development was lower than the level of developments of some countries that were mentioned as beneficiaries. So India challenged the European preference scheme, and they were unhappy with the fact they were not parties to it, they were not beneficiaries to it, though their level of development as compared to, well, based on all the basic, most commonly used criteria for the assessment of the level of development, was lower than the level of the beneficiaries. Therefore, India initiated a dispute. The case was called EC tariff preferences. It is one of the examples of cases that were resolved on the basis of the enabling clause. And India effectively managed to win the case. And the scheme, which we now know as GSP, was reviewed so that to accommodate the findings of the appellate body. So India initiated a dispute against those tariff preferences as long as it was not eligible for it, it was not a beneficiary for it. So it is subject to control by the WTO dispute settlement body. Now let's find out what is meant by this generalized non-reciprocal and non-discriminatory, and why did India have success in the dispute. So to begin with, in that case, the appellate body said that there can be still different subcategories of GSP beneficiaries. And it is not that all developing countries necessarily have to be included. Countries can introduce their own variations. And according to the appellate body, the enabling clause does not prohibit preference granting countries from according different tariff preferences to different subcategories of GSP beneficiaries. However, this division into classifications, this provision or non-provision of preferences, shall be based on the remaining conditions of the enabling clause, as I said, non-discriminatory, non-reciprocal, and generalized. What is generalized? So in order to understand what it means, we need to understand the underlying reasoning behind this wording. So when reviewing this text, the appellate body says that the original drafters of the enabling clause sought to eliminate the existing special preferences that were granted only to certain designated developing countries. And they wanted to eliminate the system of special tariff preferences, which were not generalized, but which were based on historical and political ties between the developing countries and their former colonies, between the developed countries and their former colonies. So in order to be generalized, the system necessarily has to be general, and it shall be developed as a common tool that would approach this issue and not be tailored at the needs of particular potential recipients. And the second important element, the system of tariff preferences like that shall be non-reciprocal. So in order to give tariff preferences, there can be no connection with getting tariff preferences from the other country. We do not expect any reciprocity. It's a unilateral decision to open up your market for the purposes of stimulating development. You can do it or you can just not do it. It's up to you. It's your own choice, but you cannot make it dependent, make it conditional on reciprocity. So if your products are subject to tariff treatment, which is more preferable, then I will open my markets. This is not how it works. The system shall be non-reciprocal, and then it shall be non-discriminatory. And it was exactly the reason why India succeeded in the dispute. Because when we say non-discriminatory, we say that there should be some identical preferences to all similarly situated beneficiaries. And there should be some objective criterion based on which you determine those groups of beneficiaries or not, those countries which get the benefits and those countries which do not get the benefits. The history of that particular dispute was that the European regulation contained no criteria or standards to provide a basis for distinguishing beneficiaries. And it was unclear why someone is included in the more preferenced group and others are not included. So the EC never managed to explain those groups to the panel, and there was no basis for establishing whether or not a developing country qualifies for those preferences. And because the regulation did not define the criteria or standards, there was no basis to determine that the scheme was not discriminatory. So fundamentally, most importantly, when determining which countries will be beneficiaries of such preference in tariffs and which countries shall not benefit from those preferences in tariffs, countries necessarily have to find an objective criterion, which can be different. There is no, well, EU and Russia use this World Bank classification, but it can be any other classification countries like. It is not necessarily GDP per capita. It can be how many teachers there are per 100 number, or per 100 of, or per 1,000 or per 100,000 of population. It can be any criteria that is linked to development, but it should be an objective standard so that you make this decision. And in order to avoid any complexities, difficulties, EU switched to this World Bank classification, and Russia also applies it. Well, the Eurasian Economic Union applies it. However, countries can implement other schemes. They can appoint those countries which they consider developing on their own without using the World Bank classification. But these classifications necessarily have to be based on the objective criteria. So this is it as for the enabling clause. This is one of the major important and tariff preferences for developing countries. This is an extremely important exception under Article 1. The second exception is Article 24, regional trade agreements, free trade areas and customs unions, which will be covered in our next lecture.